we should consolidate everything into a final hearing and also and give you time to look at whether or not you can issue your opinion on it's trial de novo. We can do it all at one hearing as opposed to piecemeal this thing. It's more expeditious, more efficient for the courts, more efficient for us. In the meantime, if they want to try to do some discovery, great, but I want it to be a short window to get it done, so we can get this thing up and down. Sorry, Ron. I don't dictate your, I didn't mean that towards you. We'd like to get as quick as possible.
I understand. All right. Mr. Richardson,
You're right. We have no problem consolidating. It's assuming that we have enough time to do some discovery, but I can't imagine we need to do extensive discovery. So, assuming that Plaintiff was cooperative, we could probably do it fairly. But I also agree that, especially the county, has been through a lot with this process, and to do it and then do it again, and possibly the third time, seems like a potential unnecessary expenditure on the county's part. So we have no problem consolidating with what we're doing.
In looking at the time frame, I appreciate both sides, EQT's position and Mr. Richardson's position, and no disrespect to any counsel here, but any time that you suggest that you're going to be able to quickly depose experts, over 27 years of practice in trial law, that never happens. It's very hard to do that, and I think the time frame has to be such that that can be done where you can accommodate all parties to be present. While Mr. Richardson may have this case and this case alone, all of us other attorneys have other cases that we do have to deal with from time to time. No disrespect, but I mean, seriously, we're all trial lawyers. We all have judges telling us to be here or there, and I would just encourage the court to enlarge the window a bit so that we can get these experts deposed if parties want to depose them. For the Dodgers County Commission, we are deposing no one. We're going to take them on cross-examination live at the de novo appeal. Here.
thank you, Mr. Penn. Mr. Stevens, any position?
I have nothing to add.
Just briefly, for the record, I defer to Mr. Tennant's sage wisdom regarding deposition scheduling, and I also would just like to refute his suggestion that my mother-in-law is my own plan.
Most important.
They are very patient with me right now. Thank you.
All right, thank you, Mr. Richardson. Well, I want parties voted. That's your decision. The court would be prepared to go forward today on a hearing for preliminary injunction. And it certainly wasn't my intention to delay this matter. However, I understand the parties' positions, and what I'm hearing is that given the issue regarding the notice raised by the interveners, the parties would prefer to have additional time to incorporate all issues into an omnibus hearing pursuant to these proceedings for purposes of addressing not only the issue of the preliminary injunction, but also the potential issue of the appeal, and the propriety of the appeal of the decision of the County Commission acting as the appeals board under floodplain ordinance. Let me ask this. Does anybody want to submit any authority with regard to the propriety of this court entertaining an appeal of the Commission's decision in that regard?
No, Your Honor, for the Dodgers County Commission, our position is the same.
Your Honor, from the EQT's perspective, we think you laid the record today. However, and so we do not want to, unless interveners want to do something, we would just ask a week or 10 days to reply if they're ready to submit.
Interveners desire to submit any authority on the issue. I mean, I'm not telling you got to, I'm just giving you that opportunity. Since it was a matter of
you up on the opportunity to submit authority. Stuff like that, just a little bit.
all right, how much time do you think you need, Mr. Richardson?
7,
Okay.
only because I have a brother who has a wedding.
And that's what?
A wedding.
All right.
Otherwise, I could do it quicker.
We'll submit our reply within 3.
All right, so, Mr. Richardson, you can submit your brief within 7 days. The plaintiffs and any other counsel or parties may reply to that within 3 days. All right. And in terms of the window for purposes of scheduling this, I would take the position that it won't be any longer than it has to be, or any shorter than it needs to be. So what I would probably do is try to get some type of indication from the parties, if you can let me know, and keep me in the loop in terms of any depositions that you're scheduling, when those have been scheduled for. I'll look at those time frames and then try to establish a new hearing time based on when the parties are able to accomplish that. Mr. Patterson?
I'd like to consult with the other side, so we would have to do and try to get it done from today.
That'd be great. I mean, we're here, let's take the time to do it, let's get it ironed out.
Otherwise, it's going to be, well, I can't go back to you, call you back, and we'll be 6 months coming back here, just looking at you, saying, can we get a schedule, and I want to get it done.
We certainly want to avoid that. So while we're here, let's take the time to do that. Let's take a recess, check with your experts, see what they can be proposed, and then if we can get back on the record, address that, maybe we can